When we talk about incapacity, when the incapacity occurs or the incapacitating condition begins matters, whether guardianship is the only option you have or whether you can use some of the alternatives such as powers of attorney. And I remember last time at the presentation there was some discussion about powers of attorney. So we're just going to spend a couple of slides on powers of attorney just to kind of address those issues. But in Georgia, the magic age is 18. I believe there are some states where the age is 21. And so sometimes people have the idea that, you know, they have to make this decision before they turn 21. But in Georgia, that age is actually 18. And you know, there are some advanced planning techniques that can be used. And otherwise, you do have to look at the guardianship and conservatorship process. And so we're just going to take a quick look. And
one thing I'd like to add, and probably doesn't apply to a lot of you here, but may apply to some of your friends, where you have a parent is a parent of a child until they are 18, unless they're emancipated or their rights are terminated or something like that. But you are not conservator of your minor's money. And where you've got medical malpractice settlements in some cases, and you get settlements, there may need to be a need for a conservatorship by a parent prior to the age of 18. I don't want to dwell on that, but just when we talk about the over 18 need for a parent to have custody and control versus under 18, money is an entirely different thing when you're talking about minors and when you've got medical malpractice issues out there.
That's a good point, because we're going to talk about guardianship and conservatorship. Those are actually two different concepts, but they are all on the same petition. And they have similar requirements. So where they diverge, hopefully it'll be clear, and hopefully we'll be able to address those easily. A power of attorney is an agreement which allows your agent to act on your behalf if you're unavailable or incapacitated. It can deal with finances, it can deal with healthcare decisions. You know, powers of attorney, hopefully all of you in this room have powers of attorney for yourself, hopefully at least in the healthcare area, so that if you can't make decisions for yourself anymore, you've named somebody who can make those healthcare decisions for you. The new form in Georgia is called the Georgia Advanced Directive for Healthcare, but the old form works, or pretty much any kind of healthcare power of attorney works in Georgia. One problem we have with financial powers of attorney in Georgia is we do not have a law that requires anyone to accept them. So you might have a very good financial power of attorney, but the bank won't take it. And right now, there's no way to force the bank to take it. So sometimes we're still forced into a conservatorship because these don't work. And here's where, addressing our situation here, in order to do a power of attorney, you have to be over the age of 18. So if your child is under the age of 18, if you had your child sign a power of attorney, technically it's null. You also must have capacity. And here we go back to that word. You know, what exactly does that word mean? And that's what this whole concept of guardianship is about. You know, if that individual doesn't have capacity, then they can't enter into that power of attorney.
If I may, we end up a lot of times where people are simultaneously filing a guardianship action in my court, and while that's pending, they'll have somebody sign a power of attorney. So you have somebody who's simultaneously saying, Mark, sign this power of attorney. Judge, he's not competent to do anything for himself at the same time. So you want to be careful about the timing of these things. If you're alleging someone's not competent or having capacity, you don't simultaneously want to have them signing contracts, which is what a power of attorney is a contract for service. Because they, by definition, and your own allegation under your sworn testimony or your sworn pleading, you swear to the facts stated, and you're saying that they're not competent, but you're having them file or having them sign a power of attorney. It just convolutes your issue a little bit when you're talking about people who are already over the age of 18 and signing powers of attorney.
You have to understand, and it has to be an independent choice. It's not enough to put it in front of them and say, here, sign this. It's going to help us. I know a lot of parents, it's the easy way out. It seems like the easy way out. But as Judge Wolk was mentioning, it can actually lead to trouble.